Hello, how are you today? This is Bong Soo-jung, Korean labor attorney. Today I'd like to talk about a labor case related to the prohibition of interference with employment. This violation is the most severe punishment charged for the employer. So that is the case I want to explain today. So when the employee who just got a job in big construction company, this labor law firm, and asked the question. He until the end of January, he worked for some big public companies. In that company, he was in charge of the asset management. So this his public company had some the construction project. So then some worker, like very subordinate worker, received a special bribe from such a construction company. That was 3 million won. Then after he recognized it, he asked the employee, "You must return that money." And he gave him some disciplinary punishment. Then he transferred him to work in other department of that public company. So he thought everything is solved, but later someone complained to the police. This public company received the bribe from some construction company. So because of that, he has to get some the police investigation. So then the inspection team recognized that, and it's been almost 2 years ago. So but there are no more because the police investigation was going on. There are no the result of that investigation was revealed. So he thought everything is solved. Then because he got to the age, the wage peak system is applied. So he could not accept reduced salary. So he decided to work for private company where he can earn more money. So he quit his job by the end of January 2022. Then immediately he moved to the private company. He started to work there the February 10th, 2022. Then this public company informed him the employee could not quit his job because his private case was not resolved yet. So he was so worried if this private company knew he was still employed by the public company. Also, he was engaged in such a private case, he would be dismissed. So he's so worried. So that's why he visited this labor law firm and asked for consultation. So in that case, I explained to him, calm down, there will be no problem. There is a more the compulsible the rule is applied for this case. That is Article 4 of the Labor Standards Act, prohibition of interference with employment. So since you submitted the letter of resignation, your employment is terminated within 30 days, even though the company refused to accept that termination letter. Because according to the Article 660 of the civil law, one party can inform their termination of employment, then the other party must accept. Also, that is valid in 30 days after receiving the document. So that is what I explained. So if company continue to prevent him from getting new job in that private company, then this will be a severe violation of the Labor Standards Act. That is what I explained. So the prohibition of interference with employment is very severe punishment if employer violate for this the article. Okay, this is all about this case. Thank you for watching. Bye bye.